you talk about your client interaction and getting your client ready to be there in trial. And the difference in the amount of time it takes to prepare, in my view, varies wildly on whether your client's going to testify. And if your client's going to testify, you've got to spend a significant amount of time getting them ready. I generally, if my client's going to testify, I sit them down and I give them a blistering cross-examination, just so that they are clear on how ugly it can be. It's almost inevitably not as bad as the prosecutor ends up being. The prosecutor's usually much more gentle than I am. But I want them to feel it. I want them to understand, exactly how intimidating it can be. And, our clients are not used to testimony speak. They don't understand that when you ask a question, you need a succinct answer back. They think that, I'll just talk and I'll explain my side of the story the way I want it. And they're not going to get away with that come trial time unless they've really been sort of, woodshedded, they're going to blow it up. And it makes an enormous difference. I can tell you, a testimony prepared client telling his own story, it's night and day. And I'll get into that with one of these cases. Obviously you want to make sure you're prepared for punishment. You want to have gotten whatever family, friends, character witnesses are available. There's records that can document mitigation. You want to have tracked all that stuff down. So that's the basic checklist, all right? And I don't think I'm telling anybody much that they don't know, but that checklist is, I have it in a word form rather, and I'm told there's not going to be a blast of documents available to all attendees, but if anybody wants that checklist, they're more than welcome to email me, and I'm happy to send it to them. I find it very useful just as sort of a starting point in getting ready. It's certainly not meant to be this is all you need to do and you will definitely be ready. What it is it gives you a roadmap on how to get from wherever you are in your state of readiness to becoming trial ready. So from there, once you've gone through this checklist, to me, you can break down trial and into the categories I have up there. That how much time are you going to spend thinking about pretrial motions? How much time are you going to spend thinking about your voir dire and thinking about cross-examination or opening statement or whatever? And I would tell you, for my own purposes, I don't spend hardly any time on opening or closing. I have some general themes in my head, some general ideas about the case in my head that I kick around, and I spend enough time behind the wheel that I can talk to myself, and I go jogging and I can think about it then. But I don't spend time like trying to draft a closing argument. And having seen several junior lawyers come through the public defender's office, to me the biggest mistake that I see them make is trying to script trial. I would echo what Casey said before, that you can't do that. And to the extent you try, you are being counterproductive. The evidence is almost always different than what you expect. There's always variances, there's always changes, and I take whatever my general spiels are from discussing proof beyond a reasonable doubt or discussing the presumption of innocence. I take those and I take the facts of the evidence as they roll out, and I incorporate them into, I incorporate those facts into in a very sort of unrehearsed way, which I think creates a level of authenticity like Casey was talking about. I completely agree with that. So I think you're unwise to spend any time trying to write a beautiful, persuasive closing argument or even an opening statement. I mean, you might think opening statement's the beginning of trial, at least that part can be crafted, but they can't. I mean, you're never going to give an opening statement unless the prosecutor's given one, and whatever you have to say is going to be in response to what they had to say. And you don't know what they're going to say till they say it. generally, if you can stand up and say, hey, it's not as bad as that guy's making it sound, just hold on. If you can get them to do that, then that's what you need out of opening. I also don't spend a lot of time preparing for voir dire. Now, I'm not trying to suggest that voir dire isn't important. It is hugely important. But again, the idea that you're going to have any control over the 65 assholes sitting in front of you that don't want to be there and that have, you know, all kinds of misdirection and direction that they want to go in, I think that's foolish. And I have generally, 4 or 5 specific challenge for cause questions that I want every single one of those 65 people to answer for me. I have my spiel on each one of those topics. You know, are you going to give more credibility to a cop? Are you presuming the defendant is innocent? You know, I put this on a piece of paper and I hold it out in front of all 65 and I make every single one of them answer me. And one of the side benefits of that is it doesn't take a lot of preparation. And so where's the preparation? Where do you focus? And for me, you know, if my client's testifying, then I spend quite a bit of time with them, getting them ready. Otherwise, the bulk of my preparation time is spent on cross-examination. And I would say in every single case, what I find is that the cross-examination almost always ends up being the bulk of the time that I spend. And so, you know, in thinking about what I wanted to say and in sort of going through some of my last trials and trying to understand, you know, how to go about preparing for cross-examination, you know, I started looking at the witnesses, and they basically fell into 3 categories. And it's not to say that every witness fell into only one category. Generally, the witnesses don't just fall into one category. But there's essentially 3 things I'm trying to get out of them. One is if they are making inconsistent statements. I want to get them. I want to make sure that whatever they've said differently in the past is brought to light. And this number 2 basically applies to police or, you know, the non-civilian witnesses, but sometimes civilian. What did they not do that they should have, right? What is there out there that they really should have done but they didn't do? And the last one is, what did they actually do that helps prove whatever it is, you know, you're trying to get at? What is it that they did that helps your point? And so what I've done is I've got a case example for each one of these 3, and I want to go through them. These are each real trials that I had, or at least prepared for over the course of the summer. And the first case was an adult sex assault, and it was a interesting situation. My client was about 60, and so was the complainant. He had, by her account, helped her with the yard once or twice, and she said, I let my dog out early one morning, and he was there, grabbed me, said he wanted some pussy, and dragged me inside and started to strangle me till I was unconscious, and tried to have sex with me, but couldn't actually do it because he couldn't get his penis to work. And so, you know, the bad part about it is that she really had some vicious ligature marks around her neck. And that was, and she was beaten up, her face looked badly beaten. And she knew the guy, right? She positively identified him straight away, and his DNA was on her breast. The upside for us is that she was a little bit bonkers. And I wouldn't say, I don't know that bonkers is a little bit strong, but she was the kind of salt of the earth woman that really didn't, whether she was telling whether she was saying the same story consistently or not, didn't really matter to her. You know, to her, she was going to tell it however the words happened to come out of her mouth, and if it happened to be different tomorrow than it was today, that didn't matter because in her head, it just happened however she's going to say it happened right now. And And she had no DNA in her vaginal region. So, basically our defense was that they got into a fight, but there was nothing sexual about it, which I don't think the prosecutor really conceived of that defense, because the way this whole thing happened is there was an incident here in Houston. The defendant then left the area and went to Austin, where he was convicted of strangling and raping a woman. And he was in prison. And he was in prison when the warrant for Houston came out. And so basically, once he finished with his sentence in Houston, in prison, he was bench warranted back to Harris County. And and this proved to be really really useful in terms of getting the inconsistent statements together, because the way this happened, the woman, she called the police pretty quickly, certainly with that morning that it happened. She then was taken to the hospital, gave a statement to the SANE nurse. There was police follow-up, and there was some sort of dispute about how cooperative she was going to be with the police. And she didn't seem like she wanted to come down and talk to them particularly, and it wasn't clear whether she just wasn't motivated to come down or whether she had some other issue. But basically, the police just dropped the case for a little while, and it wasn't until the CODIS hit from him picking up this case in Austin, right, that it came back that the police resumed their investigation. And so then you have a fourth statement from the second following up officer, and then there's the DA rip call, and then there was even another DA statement where they interviewed her in getting ready for trial, and the prosecutor was very useful, very helpful in turning over all of her notes about that. And then there was my investigator that talked to her. And between all of these different statements, I mean, she had major variances. And so what I did, and this is proven helpful in a number of cases, is I sort of reduced all of her inconsistencies to one page. And so, for instance, did she know the defendant? How well did she know him? At first, she seemed to say, well, he did my yard one time, but I didn't really know him all that well. And then it sort of came out, well, we had friends in common. And then it came out, well, he might have come inside for a sandwich now and again. And it evolved, right? How did she identify him? Her initial statements was that she never saw his face. She just recognized him by his voice, right? These were the first couple times she said that. But as her interviews kept going, it became clear that she said the reason why he stopped was because I looked him in the eye and I asked him, why was he doing this to me? Right? Well, if she looked him in the eye, then she saw him, right? She didn't identify him by his voice. And how afraid was she of him? Initially, the initial accounts were that she was terrified and she was in fear for her life and she thought she was going to die. But over time, she started to explain that the way she kept him from being able to get an erection was she kept making fun of his penis. And she was saying, you just got a little boy penis and you're licking my vagina like a little pussycat. I mean, like really graphic stuff that doesn't sound like the kind of thing that a woman that's being raped would say. And it was through each of, it was such an unusual encounter between the two of them that you really couldn't say anything was impossible, right? I mean, I think we've all tried cases where stuff that doesn't make sense happens. And juries nevertheless buy it all because they can see this is just wild-ass stuff that's totally off the reservation, and it happens. But because of these variances over time, right, it made it seem like not only is this wild and almost incredible, but she hasn't been sticking to her story about it. She's been saying she's been at variance. And the final thing that she was unclear about was what it was that had been used as a ligature. Her initial accounts was that it was a cord or that it was a wire. And when the second officer came back to her to interview her after the CODIS hit, she produced this yellow twine rope and told him, this is what was used to strangle me, and I've kept it as a memento of my strength for having survived this incident, right? But then when she got on the witness stand, she backtracked from that and said, well, it could have been a wire. And the reason why this ended up being meaningful is that I think for the jury, when the jury went out, there were some that were on our side, there were some that were not on our side. But all of them had to agree, we don't really know whether it was a rope, right? Even she acknowledged she doesn't know whether it was a rope. The pleading said it was a rope. It didn't say it was a wire. It didn't say it was anything else. It said it was a rope. And even the sort of states-oriented jurors, it gave them a place to stand to say, all right, this accusation, as it's pled, I can't say that's true beyond a reasonable doubt, right? So the point is, when you're dealing with inconsistent statements, I think I'm not a person that prides himself on his organization, but it is really important to be organized and to have it readily accessible. And I would say, if you can reduce the inconsistent statements to one page, where you can go after that witness and you don't have to go flipping through, all these offense reports with all these different accounts of how she may have said it one way versus how she said it another way. Have it all right there on one page, and it will pay dividends. And you may even want to make a chart, on the butcher pad that the court has available to you, there where you can say, look, you said it was a rope, and then maybe it was a rope and a cord, and then it was definitely a rope. These things, it makes the